All right, let's jump right in. We're going to build an essential guide to help you absolutely crush your contracts exam. You know that feeling, right? You're staring at a huge, dense contracts problem on an exam, and you're just thinking, where do I even begin? Well, that's exactly what we're going to tackle. I'm going to give you a step-by-step framework to turn all that chaos into total clarity. So, here's the game plan. We're going to walk through the 6 crucial stages of contract analysis. We'll start with the big picture, your blueprint, figure out which rules apply, and then get into the nitty-gritty of what makes an agreement and, what makes it actually stick. Okay, first things first, let's talk about the master blueprint. This is the one tool that will guide you through every single contracts problem you will ever face. Seriously. And here it is, the famous IRAC method. Issue, rule, analysis, conclusion. Think of it like your personal GPS for legal problems. For any contract question, you just follow these 4 steps, and I promise you will not get lost, no matter how complicated the facts get. And look, when you strip everything else away, this is what it all boils down to. Seriously, burn this formula into your brain. Contract equals mutual assent plus consideration. Mutual assent, that's just the agreement, right? The meeting of the minds. And consideration, that's the bargain. We're going to break down both of these pieces. All right, now for the first, and I mean the most critical question you have to ask yourself right at the start. Which rulebook are we even using? This is a huge deal because your entire analysis hangs on this one choice. Is it about the sale of goods? Things you can touch and move like a car or a phone? Then you're playing in the UCC's sandbox. Is it about services, real estate, or something like that? Then you're dealing with common law. You have to state this right at the top of your answer, because if you get this wrong, well, the rest of your analysis could be completely off base. Okay, but what if you have a mixed contract? Like you're buying some really complex software, but a huge part of the deal is them installing and customizing it for you. What then? That's where you use the Predominant Purpose Test. A court is basically going to ask, what was the main point here? Was it the thing or was it the service? And whatever the answer is, that's the rulebook you follow. So you've picked your rulebook, UCC or common law. Great. Now we have to actually find an agreement. And every single agreement starts with one thing, an offer. It's the starting pistol. Now, a legal offer isn't just some casual suggestion. It has a very specific 3-part checklist you need to look for. 1, was there objective intent to make a deal? 2, were the key terms definite enough? And 3, was it actually communicated to the other person? If you're missing even one of those, you don't have a real, valid offer. It's that simple.
And this idea is just perfectly captured by the objective theory of contracts, inspired by cases like Lucy v. Zamer. It really doesn't matter if you were secretly joking when you scribbled a promise on a napkin at a bar. What matters is what a reasonable person would think based on what you said and did. The law, plain and simple, does not read minds. An offer just hangs there in the air, totally powerless, until someone accepts it. But, and this is a big but, how that acceptance has to look changes completely depending on which rulebook you're using. Pay attention here, because this is a classic exam trap. Under the old common law, you have the mirror image rule. The acceptance has to match the offer exactly. Any tiny change kills the offer and creates a counteroffer. But the UCC, with its battle of the forms, is way more flexible. It's built for how business actually works, with people sending forms back and forth. Under the UCC, you can still have a deal, even if the terms aren't a perfect match, which honestly saves a lot of agreements from falling apart over tiny details.
Okay, let's talk about timing, because it is absolutely crucial. And this is where the Mailbox Rule comes in. Get this. The second an acceptance is sent, the moment you hit send on that email or drop that letter in the mailbox, the contract is formed. Boom, deal's done. But for everything else, like the offer itself, or a rejection, or someone revoking their offer, none of that counts until it's actually received by the other person.
Okay, so you've got an agreement. You have an offer and an acceptance. We're done, right? Not so fast. The next big question is this agreement legally enforceable? And to answer that, we have to talk about consideration.
The easiest way to think about consideration is as the price of the promise. It's the quid pro quo, the this for that. Both sides have to give something up, something of legal value. That's what makes it a real bargain. And this is the bright line that separates a real enforceable contract from just, an empty promise to give someone a gift. And the famous case of Hamer v. Sidway makes this super clear. Consideration doesn't have to be money. It can just be giving up a legal right. In that case, an uncle promised his nephew a bunch of money if he didn't drink or smoke until he turned 21. By giving up his legal right to do those things, the nephew provided consideration. And just like that, the uncle's promise became a real, enforceable contract. Why? Because it was a bargain for exchange. Okay, this slide right here, this is your ultimate cheat sheet for spotting consideration issues on an exam. On the left, you've got the real deal, the things that count as a bargain. On the right, you have the fakers, the things that look like consideration but aren't. For example, you can't get paid for something you've already done. That's just past consideration. And be on the lookout for those sneaky, illusory promises. Where someone says something like, "I'll buy it if I feel like it." That's not a real commitment, so it's not real consideration. So what happens if you have an agreement, but there's no consideration? Is the whole thing just dead in the water? Well, not always. There are few special situations where a court can step in and enforce a promise anyway, basically to stop a really unfair outcome. And these are what we call consideration substitutes. The big one you're going to see all the time is Promissory Estoppel. It's not a contract, it's a tool of fairness. It kicks in when someone makes a promise they should reasonably expect the other person to rely on it, and that person does rely on it and gets hurt because of it. Think about someone who quits their job because they were promised a new one and then the offer gets yanked away. The law can step in there to prevent a massive injustice, even though there wasn't a formal bargain for contract. So here's the real takeaway from all of this. Memorizing a bunch of rules is fine. It's good. But what's truly going to make the difference is mastering this analytical framework, that three-part structure. First, governing law, then mutual assent, and finally, consideration. That's the skill that will let you walk into an exam and deconstruct any problem they throw at you with total confidence. Once you start using this structure, you'll begin to see the hidden legal architecture everywhere. It's in your phone contract, your lease, your student loans. It's the foundation of all these agreements. And now you have the blueprint to understand how they're all put together and how to take them apart.